The Supreme Court just handed down a 9-0 decision that could change everything about warrantless searches in your home. And now, there's a new case trying to expand that ruling even further. We're talking about when police can kick down your door, enter without permission, and potentially confiscate your firearms based on nothing more than a bad feeling. This isn't some distant legal theory. Oral arguments are happening next Wednesday, and the outcome will directly impact your Fourth Amendment rights. Before we get into the details, hit that subscribe button right now because YouTube loves to unsubscribe people from channels like this. And we need your support to keep bringing you these critical updates on cases that affect your constitutional rights. The Caniglia case, the 9-0 ruling that started it all. Back in 2021, the Supreme Court made a decision that sent shockwaves through law enforcement agencies across the country. Edward Caniglia had an argument with his wife where he dramatically placed his handgun on the table and told her to end his misery. She left for the night, and the next morning when he wouldn't answer his phone, she called the police out of concern. Officers showed up, found him perfectly fine on his porch, but decided he needed a psychiatric evaluation anyway. But the moment Caniglia left for the hospital, those same officers went back to his wife, lied to her face, told her that her husband had given them permission, and then proceeded to confiscate every single firearm in the house. When this case reached the Supreme Court, something remarkable happened. In a political climate where the court rarely agrees on anything, all 9 justices, liberal and conservative alike, ruled that what the police did was completely unconstitutional. But here's what most people don't know. That unanimous decision is now being used as a weapon to argue for even more police power. And that's exactly what's happening in the case we're covering today. The Trevor Case incident. What actually happened? Trevor Case's ex-girlfriend made a phone call that would change his life forever. She told police she had talked to Trevor and had a bad feeling about the conversation, though she couldn't remember exactly what was said. When she and 4 officers arrived at his home, she suggested he might have a shootout with police. The officers peered through windows, spotted an empty gun holster and a notepad, but couldn't find Trevor inside. So they made a decision. They entered through the unlocked front door without a warrant. 2 officers headed upstairs, and 1 entered a bedroom where he noticed a closet with a curtain. What happened next is where the stories split dramatically. The official police report claims the officer saw Trevor's face and a black object in his hands. The officer fired, hitting Trevor in the arm, with the bullet continuing through into his abdomen. But Trevor's version tells a different story. He says the officer fired in just 0.4 of a second after seeing the curtain move. The officer's own words at the scene were chilling. He saw the curtain move and just let one fly. What nobody's talking about is that this case isn't really about whether the shooting was justified. It's about whether police should have been in that house at all. The legal battle and what's at stake. Trevor Case argued something that should be straightforward. Police violated his Fourth Amendment rights by entering his home without a warrant, so any evidence they found should be thrown out. But here's where the system failed him. Then the Montana Supreme Court rejected it too, but barely. It was a 4-3 decision, meaning 3 judges actually agreed with Trevor. Now the United States Supreme Court has agreed to hear the case, and the question they're being asked to answer is critical. Can police enter your home based on less than probable cause just because they think there might be an emergency? The current standard requires probable cause, meaning police need solid, concrete reasons to believe an emergency is actually happening. But Montana and other states want to lower that bar to mere reasonableness. Probable cause is specific. Officers need facts and circumstances that would lead a reasonable person to believe something is true. Montana is also trying to revive something called the community caretaking doctrine, the exact same justification the Supreme Court unanimously rejected in the Caniglia case. But what's really alarming is who's now jumping into this fight on Montana's side, and their argument might surprise you given recent political promises about protecting constitutional rights. The federal government's push for lower standards. Here's where things get really concerning. Multiple federal agencies and state governments have filed briefs supporting Montana's position to lower the standard for warrantless home entries. They're arguing that requiring probable cause puts officers in impossible situations during emergencies, and that a reasonableness test gives them the flexibility they need. But let's be clear about what flexibility really means in this context. It means subjectivity. It means officers making split-second decisions based on hunches rather than facts. The briefs supporting Montana claim that first responders need breathing room to save lives, but they conveniently ignore that the probable cause standard has worked for decades without preventing legitimate emergency responses. Trevor Case's attorneys fired back hard in their reply brief, pointing out that even the supporters of this reasonableness test can't agree on how it should be applied. Some argue it should consider the officer's subjective belief, others say it should be purely objective, and still others want some hybrid approach. If legal experts and government lawyers can't figure out how this test works, how is a patrol officer supposed to apply it correctly at 2 in the morning when someone calls in a welfare check? The implications for every American. This case isn't just about Trevor Case, or even just about gun owners. It's about the fundamental protection every American has against government intrusion into their home. Your home is supposed to be your castle, the one place where government power is most restricted. The Fourth Amendment was specifically written to prevent the kind of general warrants and random searches that British soldiers used against colonists. Probable cause has been the standard because it's clear, it's measurable, and it forces police to have real justification before crossing that threshold. If the Supreme Court adopts a reasonableness standard instead, they're not just tweaking a legal test, they're fundamentally changing the balance of power between citizens and the state. The Coniglia decision was supposed to strengthen our rights by making clear that community caretaking doesn't apply to homes. But Montana is trying to open a different door, the emergency aid exception, and lower the standards for when that applies. 9 justices unanimously protected our rights 3 years ago. The question is whether this court will stand by that protection or carve out exceptions that swallow the rule. If this case concerns you and you want to stay updated on how the Supreme Court rules next week, subscribe to this channel right now because we'll be breaking down the oral arguments and what they mean for your rights. Turn on notifications so you don't miss the follow-up when this decision drops, because your Fourth Amendment protections are literally on the line here. The only way we can keep fighting back against government overreach is if we stay informed and spread the word to everyone who cares about constitutional rights. Share this video with your friends and family, because what happens in this case will affect every single American's home for generations to come.